The governorship candidate of the Labour Party in Lagos State, Gbadebo Roads Vivo, GRV, has filed his notice of appeal before the Court of Appeal, Lagos, challenging the decision of the State Governorship Tribunal, which upheld the return of Governor Babajide Sanwo-Olu. The 24-page document has been served on the council to the respondents. The Independent National Electoral Commission, INEC, the governor and his deputy, Obafemi Hamzat, as well as the All Progressives Congress, APC. Joining us now on the morning show is Peniela Akintujoye, legal counsel to Gbadebo Roads Vivo and principal partner, Caritas Law and Partners. Good morning and welcome to the morning show, Mr. Akintujoye.
Good morning. But I thought to clarify that I'm not part of the legal counsel of GRV.
Okay.
No, I'm not. I'm a legal practitioner. You can call me an amicus curiae.
Okay.
A friend of the court, yes. Right. I've read the judgment and I have opinions on the judgment of the tribunal in the interest of justice. Because in short, in that judgment, the court noted that on the issue, the main issue for contention in the case, the decided authorities of the court are not yet so much.
Okay, wait till the questions come.
Okay.
Thanks for the clarification.
No, but the clarification is important. Yes, because I was wondering, and I keep complaining, when an appellant has gone to court, why argue your own case? You know the principle. Never do this in causa sua. Yeah. So it's good. You are amicus curiae. Yeah. But okay, can you take us through the 21 grounds of appeal? Some of the issues raised in the appeal, since you are familiar with that appeal, and is there a date for hearing yet? But what are the key issues that Gbadebo Roads Vivo has taken up in the notice of appeal?
Well, I think that it would not be proper for us to discuss the issue of the grounds of appeal because it's an issue that is already before the court.
Yeah, but do you have a date of hearing yet?
No, because no date of hearing has been fixed yet, because the grounds of appeal has been filed. I'm aware it has been filed, but all the other documents have not yet been put in yet. They have not yet put in. It's the notice of appeal that has been filed, the notice and the grounds, but the appeal itself, the brief of argument, has not been put before the court.
Yeah, but you said you read, the ruling of the tribunal.
Of the tribunal, absolutely.
The objection to which, is the basis for this appeal, right? Yeah. So, and you said, okay, more or less, that the tribunal erred in law. How did that tribunal, err on points of law?
Thank you. Now, the gravamen of the issue at the tribunal was the question of the qualification of Dr. Hamzat to contest the election under section 182 of the Constitution, that talks about the fact that if somebody has voluntarily acquired the citizenship of another country and has taken the oath of allegiance of another country, the person is going to be disqualified from being able to be elected as governor or deputy governor, as the case may be. So that's the gravamen of the contention between the parties. The other party, the respondent, argued that that section 182 is made subject to section 28 of the Constitution. And the argument is to the effect that if somebody is a citizen of Nigeria by birth, acquisition of the citizenship of another country or subscription to oath of allegiance of another country does not preclude a Nigerian citizen by birth from contesting and being elected as governor or deputy governor, as the case may be. Now, but for me, the approach of the court so far had been the literal interpretation. And
which is valid.
Yes, but I think that there is already an absurdity that is leading us into. And it is a position also that if an approach of interpretation of the Constitution that is literal leads to absurdity, then the court can adopt the golden rule, and this is the absurdity. Based on the reasoning of the court, that section 182 of the Constitution would only be applicable to a Nigerian citizen other than by birth. That is, a Nigerian citizen either by registration or naturalization. But the fact of the matter is that the Constitution of Nigeria never emphasized in the first place that a Nigerian by registration or naturalization could even stand for election into the office of a governor or president by virtue of Section 177 of the Constitution. Section 177 of the Constitution already states that anyone who will be qualified to run and contest for governor of a state or president must be a Nigerian by birth. So it then means that the Constitution really has never emphasized a situation whereby somebody who is not a Nigerian by birth could even have a reason to be disqualified by Section 182 of the Constitution. For me, that is the absurdity.
No, Counsel, I see mischief here. You mentioned literal rule, golden rule. There's also the mischief rule. Now, are you saying that Dr. Hamzat is not a Nigerian by birth? Or are you saying that he renounced his citizenship of Nigeria? Because the court, in that document, at least parts of it reported in the public domain, did not say that he renounced his citizenship of Nigeria. And the section that you quoted recognizes dual nationality for Nigerians.
Now, indeed, Dr. Hamzat, by the character of the oath of allegiance of the United States of America, which I need to also call our attention to, the character of the oath of allegiance of the United States of America is peculiar. From, for instance, the oath of allegiance of the United Kingdom, or that of India, or Canada, or Nigeria. The character of the oath of allegiance of United States of America requires that anyone who is subscribing to that oath of allegiance must first of all renounce his allegiance to any other country or state that he may have been a citizen of. I think I want to just read it verbatim as it is stated, the oath of allegiance of the United States. It says, I hereby declare on oath that I absolutely and entirely renounce and abjure all allegiance and fidelity to any state or sovereignty of whom or which I have heretofore been a subject or citizen. This is the oath that Dr. Hamzat took. And I'm saying that it's peculiar. That of the United States is peculiar.
No, I suspect that the tribunal must have been looking at issues under conflict of laws here. The fact that a man takes American citizenship does not deny that person of the citizenship of Nigeria. This is the issue, because this is international civil matter.
Yes, he took it, but in the process of taking it, renounced his allegiance to Nigeria. In the process of taking it, he renounced. Yes.
Don't let's argue.
But again, I want us to also avert our mind to the fact that there is a need. I believe that the drafters of our Constitution have not inserted that Section 182 as a decoration. Right. In that section, okay. There's a need to seek to discover what is the intendment. For me, I would think that the reasoning of the drafters of Constitution, because that's part of what we should interrogate when we are trying to interpret the Constitution, is that somebody is going to be the chief executive of a state. Must not be a person whose allegiance, who has, for instance, renounced his allegiance to the country and is the chief executive of a state. That doesn't speak well. That doesn't make sense. What of if there is an issue of conflict between that state and the country that person has is owing allegiance to?
All right. Thank you for that. I mean, from interpretations by some legal counsels who have also opposed, or perhaps who hold the position that their justices or the tribunal erred in law. And I would like you to clarify it for the sake of our audience who are not legal, perhaps minds or legal luminaries. So is the contention here about the fact that he renounced his citizenship, which he didn't, or the oath of allegiance, so that while he's still a citizen of Nigeria, the fact that he has sworn allegiance to another country whilst renouncing allegiance to his country is the bone of contention here, not the fact that he's not a citizen of the country. Is that what you're trying to establish?
Yes, he remains a citizen of the country. Okay. That is very clear as far as Section 28 is concerned. Right. But he has taken allegiance of another country.
What is the significance of that? Because that's another point. Because in terms of taking allegiance to another country, what you're saying is that in the event of crisis or war, you swear to defend that country against any other country.
Any other.
So what is the significance of that for Dr. Hamzat in this case?
Or that's already conflict of interest. It's already conflict of interest. And it's an attempt to eat your cake and have it.
So can you swear allegiance to two countries?
You can swear allegiance to two countries, but I keep emphasizing that the character of the allegiance to the United States is peculiar to the United States of America. It's peculiar. There are other countries, for instance, like I emphasized the other time, the allegiance to United Kingdom, that of Canada. All of those oaths do not require that you first of all renounce that of your previous citizenship. So the character of the United States oath requires that you first of all renounce absolutely your allegiance to any other authority, any other state or sovereignty.
Here. So what you're saying is that based on the swearing of oath of allegiance to the United States, anybody, whether it's Dr. Hamzat or anybody else, says in that oath that they renounce allegiance to any other country and swear allegiance to the United States. Is that what you're saying?
Yes.
Okay, thank you.
Yes.
Okay, so let's go back to that issue. You couch the argument in such a way that now you're saying for those that naturalize or that are not by birth, then obviously, they cannot stand because the Constitution definitely just pushed them out. I want you to make further explanations. And secondly, the other parties too in this case, so for example, the PDP has also been making those arguments too about, the candidates of the Labour Party saying that according to Section 177, that he too is not qualified because it says the party must put you forward, and they keep making the claim that he was not a member, he was still a member of the PDP as at the time he made his declaration. What would you also say as regards that? And thirdly, can you read for us the oath of allegiance of these other countries you are mentioning? Let's see the difference in the character as you postulated. Do you have the oath of allegiance of the United Kingdom?
Yes,
and some other countries?
I have it. I can bring it up.
Can you? Yes. So we know this disparity.
So I should go first from the first question.
Yes.
The first, by Section 177, that talks about the grants of qualification to contest as governor of a state. Only citizens of Nigeria by birth can contest.
Okay.
That is the position of the law. So those that are citizens by either registration or naturalization cannot contest for either governorship or presidency.
Okay.
That's the first issue. The second issue...
Qualification too that the PDP has always
yes,
touted.
well, I think
and is this case of oath of allegiance conundrum, is it the only case, or also, there were talks about wire qualification and other things? Is it only the grounds of the argument?
Eventually, this issue of qualification was the gravamen of the case at the tribunal.
Okay, so talk about the qualification thing with the...
Well, I think the court has already settled that the only group that has the locus standi to challenge whether somebody is a member of a party must be those who are members of that party.
So the variation in the oath of allegiance.
The variation in the oath of allegiance. For instance,
for time's sake, I thought you'll have prepared this to be able to make
it's available.
Oh, I'm not sure we have the time. We'll not be able to take you on this. But have a good one, all right? Thank you so much for your time.
Anyway,
we'll push it forward.
The issue is that dual citizenship does not disqualify anyone from being a candidate in Nigeria.
I have that of Britain. I don't know if I can quickly read it.
Okay, go
that
ahead.
Of Britain. Yeah. It says, I swear by Almighty God that on becoming a British citizen, I'll be faithful and bear true allegiance to Her Majesty Queen Elizabeth II, our heirs and successors according to law. I will give my loyalty to the United Kingdom and respect its rights and freedoms. That's the character of that of India, that of Canada. It doesn't require that you first renounce your previous allegiance to your country of birth.
Okay, the key issue here is that I have not read the details. You have said Dr. Hamzat is a citizen of Nigeria by birth, not by registration,
That's
not by naturalization.
Yeah.
And to the extent that the Constitution of Nigeria, 25 to 28, Chapter 2, says, you can, if you are a Nigerian by birth, you can aspire to any office. I don't think that the appeal may be standing in that regard on terra firma. But there are other issues about witnesses, about burden of proof, and whether the tribunal erred in law or not.
Yeah, but this one is the government.
Well,
is the government of the issue.
Well,
I suspect that it will also be the government of the issue at the appellate court.
Okay, the case is in court. We can't.
Yes,
let's just leave
it's
it.
okay.
Yeah.
So anyway, thank you very much for joining us.